Welcome all. This is our lecture 27, and in this lecture, we will cover the topic Trademark Act 1999. This act was passed by the Parliament of India in 1999, and it deals with the trademarks. As we all know, the Trademark Act is used to protect the use of trademark, use of it, any trademark, the administration of such protections provided to the creator or the holder of a trademark under this act is done by the controller of Journal of Patents, Designs and Trademarks. The Trademark Act 1999 deals with the protection, registration and prevention of fraudulent use of trademarks. It also deals with the right of the holder of the trademark, penalties for infringement, remedies for the damaged, as well as modes of transference of the trademark. It also provides some ways that how one can use a particular trademark for any goods and services. We will learn in the video. The trademark is defined in the Trademark Act 1999 as trademark means a mark capable of being represented graphically and which is capable of distinguishes the goods or services of one person from those of other and may include the shape of goods, their packaging and combination of colors. It could be anything, okay, or any sign. As you all know, we have different companies, different services, and everyone have some different type of marks. As take an example of some companies like Puma, Adidas, Apple, okay, all have some different marks by which they are recognized in the market, and the customer can recognize the product of a particular company. Okay, such a mark may include numerous things such as signatures, names, labels, heading. That could be anything, or a combination of colors. As like in Windows, there is a Windows. Check the marks of Windows trademark. That is a combination of 4 different colors, rectangles. It also provides the registration process of trademark. To apply for a trademark, a person must adhere to the provisions enlisted under Section 18 of the Act. It means under Section 18, the registration process is defined. The section requires any persons applying for a trademark to apply in writing in the manner that is prescribed for the registration. The registration form or the formalities will be provided under Section 18. The application has to contain the name of the mark, goods and services, the class under which goods and services fall, the period of use of the mark, and the personal details of the applicant, such as name, address. It have many things. These are defined in the Act to register a trademark. Infringement of trademark. It means that if there is any conflict between 2 or more parties regarding any trademark, so what are the provisions to infringe the trademark for use in the market? The term infringement means the violation of someone's rights. Therefore, infringement of trademark means the violation of trademark rights. A trademark is said to be infringed when there is an unauthorized use of a trademark or a substantially similar mark on goods or services of a similar nature. In such a case, the court will look at whether such use of the trademark will cause any confusion to the consumer as to the actual brand they are purchasing. It means there's the trademark should be different. No two company can claim for a single trademark. Okay, so if the court feel, then it can infringe any trademark. Classification of trademark under section 7 of the Trademark Act require the classification of trademark, and it means in which category the any goods or services are fall, so that the trademark will come under that particular class. And there are total 45 classes of goods and services in which that any trademark will fall. The international qualification system used is called NICE classification, means NCL. It was established in 1957 during the NICE agreement. According to the NCL, there are 45 classes under which goods and services fall. Class 1 to 34 are for goods, and classes from 35 to 45 are for services. These are the classes. So this is all for this class. Prepare your good quality notes.